I'm often asked by an insurance company or an adversary to have my client give a statement. Now, that raises several interesting issues. The first is my client obligated to give a statement? In the auto context, yes, the client is obligated to give a statement to an insurance company. That justification is in the auto insurance policy, which states that if anyone is seeking payment under any provision of the policy, we, the insurer, have a right to take an examination under oath. But what about if it's a third-party insurer, not your client's own insurer or the insurer that your client, the car that your client was traveling in? In the other circumstance, that is, of a third-party insurer or a non-auto case, is your client obligated to give a statement? And the answer is generally not. There may be a few reasons, not relevant here, where occasionally an insurer can cite something to justify their taking a statement. So assuming we're in the vast majority of cases where there is no obligation to give a statement, should the lawyer advise his or her client to submit to and agree to a statement? The tendency at first blush is to say no. And the reason for that is by giving a statement, you are giving an insurance company two bites of the apple. They will have an opportunity to question your client before litigation has begun, and they have an automatic right to take the deposition of your client once the litigation has begun. Therefore, they will have been educated in ways that they would not have been if that statement before the lawsuit is commenced had not taken place. That is not to say that I haven't authorized or allowed for my client to give statements before a case is in suit. And there are a couple of guiding principles for that. The first is if your client makes a good appearance and is able to narrate in a good, coherent way how an incident or accident happened. Second item to keep in mind is that if you agree to that statement, it's a matter of the two sides coming to an agreement on the terms of it, and there's no need to have a recorded interview, and there's no need to have a handwritten statement that will be signed by your client. It could merely be an interview of your client. And those two guiding principles, good appearance of the client and good narration of how the accident happened, those guiding principles will still govern even where you have not allowed for a signed statement. Now, there are other times where I will provide a statement before a lawsuit has begun. And those times really involve a situation where the client is desiring an expedited or a quick resolution. To be candid, it's harder to get that quick resolution in certain kinds of cases unless you have agreed to let the other side meet your client. However, like most things, this is a balancing situation, and it really requires the lawyer to sit down with the client in those non-automatic, non-required situations, to sit down with the client to go over to discuss what is the best approach in the particular circumstances. Thank you.